Fireworks are expected on the floor of the House Tuesday as debate on a motion tabled by Chepalungu MP Isaac Ruto resumes. The motion urges the executive to pull Kenya out of the jurisdiction of the International Criminal Court. However, the Speaker is expected to first rule on the constitutionality of the motion. A section of MPs have insisted that a pullout from the Rome Statute would necessitate a constitutional amendment through a referendum, since the supremacy of the Constitution is a protected chapter.
How can we, Mr. Speaker, withdraw from law, substantive law, through a motion in this House?
But international law expert Dr. Gachuri Musila makes an alternative legal argument that while the Constitution provides that the general rules of international law shall form part of the laws of Kenya, it doesn't mean that they form part of the country's constitution. As such, a constitutional amendment would not be triggered.
If Parliament was passing a motion to say, we are withdrawing from the Rome Statute, it will be unconstitutional. But if what they are saying is this, they are asking the President to withdraw, as provided for by the Constitution, then they are within their powers.
Article 2(6) of the new Constitution provides that any treaty or convention ratified by Kenya shall form part of the laws of Kenya under this Constitution. The Rome Statute is such a treaty, and legal experts differ on whether Kenya can cease to be a signatory to the statute without amending the Constitution.
Kenya ratified the new Constitution. My reading of that Constitution is that we will need to amend it in order to pull Kenya out of that treaty.
The treaty, once it is translated by Parliament, by passing legislation, it forms part of the body of Kenyan law like any other statute, but not as part of the Constitution.
There are fears that Isaac Ruto's motion is meant to shield the 6 personalities who are named by the ICC prosecutor Luis Moreno Ocampo as suspected to have borne the greatest responsibility over the post-election skirmishes.
Even if the President were to be convinced that it is in our interest to withdraw, ongoing investigations are not affected. So I think if that is their intention, they are going about it the wrong way, it will not be effective.
Article 127 of the Rome Statute outlines the steps that a signatory must follow to effect a pullout. The government, in this case the President, would have to write to the United Nations Secretary General giving notice of Kenya's desire to quit. The withdrawal process would take well over a year.
Because of Article 2, the international criminal proceedings are equated, they are the same with the Kenyan courts because we domesticated the Rome Statute. So the standing orders of the House do not permit discussion of a matter which is pending in court.
How then can Kenya regain control of the process and save the Ocampo 6 from making a trip to The Hague?
The only effective way of stopping Ocampo is by establishing an independent, credible, national prosecution process.
But even as the parliamentarians square it out on the floor of the House tomorrow, they have been reminded to bear in mind the plight of the victims of the chaos and the need to continuously fight against impunity. Francis Gachuri, Citizen Live at 9.